The last topic of Chapter 8 is the trial process. Criminal trials are open to the public. This is a constitutional right that the people as citizens have. It falls under the First Amendment. It's part of free speech and free press. Not only does the First Amendment apply to speaking or publishing, but it also applies to our right to receive information too. So that's where this comes from. And since the government is the prosecutor, we're entitled as citizens to examine the facts of the case that are brought against an accused and to know what is going on. And this came from a Supreme Court case that indicates that criminal trials must be open to the public. Criminal trials, though, if we have discussed so far, they are far and few between, despite the fact that it is a constitutional right to have a jury trial. This jury trial, however, doesn't have to be a jury trial. A defendant can say, I do not want a jury. I would just rather have the judge decide. That's called a bench trial, and the judge will hear the case and decide whether the defendant is guilty or not. This happens more often in a misdemeanor case. It will happen all the time in a violation case. The reason being is you're not entitled to a jury trial for a violation because there is no loss of liberty there. And in misdemeanors where a defendant is facing 90 days in jail or more, it's a right to have a jury trial. But more likely the choice, if it's a misdemeanor case, is to have a bench trial. But the defendant has to waive that in open court and actually sign something. In either scenario, let's talk about the structure of how criminal cases are adjudicated. And I guess adjudicated means like a formal judgment on a dispute, the end, what happens to the end, how it works, how it goes through the system. All right, legal rights. At arraignment, the court advises the defendant of his or her rights. Those rights are the following. The right to an impartial judge. What do I mean by that? The judge cannot have a conflict of interest. The Supreme Court has defined this impartial judge, or a judge who is not impartial, is one who has a direct personal or substantial pecuniary interest in reaching a conclusion against a defendant in a case, meaning they're already predisposed. Let's say the defendant is a relative of the judge. The judge may have already formed an opinion, right, about the defendant. So how do you get a judge off a case? Generally, they will announce that they have a conflict and they will recuse themselves. But otherwise, if the defendant believes the judge has a conflict, the defendant would have to make a motion stating that the judge has a conflict and that it's in violation of their judicial code of conduct, and then the judge would have to make a ruling. So, impartial judge. The right to be, the next right, the right to be mentally competent at trial. If a defendant cannot understand what is happening or what the role of his attorney is or can't help in his or her own defense, then they are incompetent to have a trial. So how is this determined? We talked about it in one of the earlier chapters. In New York, they call it a 730 exam. That it's in reference to the statute that indicates the procedure for determining competency. And what happens is the court orders the defendant evaluated by 2 psychiatrists. This is not for use of insanity. This is just to determine competency. When the reports come back, the judge will have a hearing to determine if the defendant is competent or not. And if the 2 psychiatrists come back and they both say the same thing, the defendant is competent, then we're going to go forward. If they say that he or she is incompetent, or if they conflict, one says competent, the other one says incompetent, the judges during this hearing, after hearing from all the parties, is going to have to make a determination. And if the defendant is deemed incompetent, then everything stops, the procedure stops, that speedy trial time clock stops, and the individual is committed for treatment until they are deemed competent. And then that begs the question, what if they're never deemed competent? Well, after a period of time, depending on what kind of case we're dealing with, a misdemeanor or a felony, the court can outright dismiss the matter. And it's really dependent on the level of the crime. And if at some point in the future the person becomes competent, the district attorney can determine whether or not they'll bring the charges back. And I speak very generally with regards to the process, but that's the general gist of competency. There's a right to be competent at your trial. You have the right to confront witnesses. This is under Sixth Amendment. There's two components to be able to question. The reason for this is to be able to question the accuser, but also to present in court at trial and participate, hence the reason for competency. You have to be able to have the ability, you have the right to face your accuser and ask your accuser questions and be present in court and participate. Two components. They call it the Confrontation Clause. It's important. Why is it important? What if a cop could just come to the stand and say, Jane Doe told me defendant punched her in the face 3 times, and the people never called Jane Doe? It's a little hard to confront your accuser because you can't ask questions, right? The jury can't assess Jane Doe's credibility. What if she lied to the cops just to get the defendant out of the house? So that's also an example of something called hearsay. The testimony isn't firsthand. But Jane, in this instance, is the accuser, and the defendant has the right to face their accuser and ask questions and hear what they have to say. There are exceptions to this rule, with the witness being present in court. What if one skips town? What if a witness skips town? Or what if a witness is disrupting court? Or what if the defendant's disrupting court? The defendant can be removed from court if the defendant is disrupting court, which means they're not participating or confronting their witnesses. But if it's their own doing, if a witness skips down, it's up to the DA to get them there or make alternative arrangements. But yeah, that becomes a sticking point for the prosecutor. But what if the defendant skips out? The trial can go forward. Judge can go forward. In child abuse cases, depending on the age of the child, the child may not be forced to testify, or in some instances they appear behind a curtain. So there are a couple very limited exceptions, but there's exceptions to the Confrontation Clause. The right to compulsory process, and this is defendant's right to call witnesses on his or her own behalf under a court subpoena. All they have to do is say, Judge, I have this witness. The witness is important to my case, and here's why. And the court must subpoena and get that person to be there. Especially, and this is at no cost to the defendant, especially if they're deemed indigent, but nevertheless in a criminal trial, it's up to the court to issue those subpoenas. The right to an impartial jury. It can be waived, right, to have a jury, but the Constitution sets forth this right. And I already explained that in certain instances, and not every case. The book says, the Supreme Court has said that only in crimes where the jail sentence maximum exposure is 6 months or more. In New York State, it's 90 days or more, where you're entitled to a jury trial. And that jury has to be impartial. We'll talk more about that when we talk about picking the jury. The right to counsel at every stage. This is a constitutional right. Can the defendant waive it? Sure, they can represent themselves. Pro se is what they call it when a defendant represents themselves, and sadly they do lots of times. And the courts will read them a litany of precautions to determine that what they are doing, they're doing voluntarily, so it can't come back on appeal to say they didn't have an attorney. So the judge has to read, it's like 20 questions to the person before they let them proceed pro se. However, court will always appoint what's called a standby counsel to be an assistant. They can't participate and ask questions, but the pro se defendant can use them to consult. Right to a speedy trial. What constitutes a speedy trial? Usually a trial within 6 to 9 months, but of course there's always court backlog. There's also motion practice. There's also hearings that happen. So that's not a hard, fast rule, but generally it's calendared for 6 to 9 months, 9 months being on the felony level, but a lot of them go a lot longer than that. Right to a public trial. As I said, trials are open to the public, especially when you're looking at high-profile cases and the press want to attend. And then it begs the question, do you think this affects the defendant's right to a fair trial when you have the press there and printing on it and putting things in the newspaper about what happened that day? Have any effect on defendant's right to a fair trial? Can the court limit the press? Can the court ban the press? Close the courtroom to the press? Nope. We just talked about it. It's a First Amendment right. Can the court issue what's called a gag order on the press? Meaning don't talk about what you saw here? No. That can't happen. Can they do it to the parties? Yes. A judge can issue a gag order that tells the prosecutor and the defense attorney and the defendant not to talk to the members of the jury not to talk to the press. If the members of the jury talk to the press, then they're going to get bounced off the jury panel because they're not supposed to talk about the case while it's going on. The right to be convicted by proof beyond a reasonable doubt. People's burden or standard of proof to convict the defendant in a criminal case. This does not mean absolute certain, but should really leave no doubt. Okay? As opposed to what's called preponderance of the evidence, which is more likely than not. I believe we've talked about the standard of proof early on. There is a diagram and on my nice slide here for you that outlines the various standards of proof, their definition, and where they fall in rulings. We are going to be more concerned with, I like how they described absolute certainty, which is not a standard of proof. And then we have beyond a reasonable doubt, clear and convincing evidence, preponderance of the evidence, probable cause, sufficient evidence, reasonable suspicion, and then less than probable cause or mere suspicion. That last one is for the search and frisk, where cops are allowed to stop and frisk and ask questions if they see that criminal behavior is afoot. That's what we're talking about, less than probable cause. Reasonable suspicion is like the next notch up for law enforcement. Probable cause is what you need to make any sort of arrest and for any sort of search warrant, get a search warrant. Sufficient evidence is for the appellate court to review. Preponderance of the evidence, while used mostly in civil trials, the defendant's defenses are proven by a preponderance of the evidence. Never will a defendant have to prove something beyond a reasonable doubt. That is strictly for a criminal trial for the prosecution. Clear and convincing evidence is a slightly higher standard. It's in between our reasonable doubt and preponderance of the evidence. In some states, the defendant needs to show it for an insanity defense, but the majority of them is preponderance of the evidence, and you will always need clear and convincing evidence if somebody's going to be committed civilly, where that, and we will talk about that a little later for sentencing. Civil commitments, A common example is sex offenders who are about to be released from prison and they have not been through the rehabilitation process. They have just sat out their sentence and are about to be released. The state might seek to have them committed and confined civilly, and that's a clear and convincing standard. But let's talk about the trial process. This is the steps that we're going to walk through for a trial. There's voir dire, i.e. picking the jury. The prosecutor will make their statement. The defendant will make their statement. Prosecutor presents first. Defense attorney gets to cross-examine their witnesses. And when the prosecution rests, the defense will have their opportunity to present any evidence, and the prosecutor will get to cross-examine. And then when all of the evidence is done and closed, as they say, the defense gets to make a closing statement. Then the prosecutor, the judge will instruct the jury on the law. The jury will deliberate and then cast their vote amongst themselves and come out and ultimately announce their verdict. And then the judge will, if the verdict's guilty, the judge will determine sentence. Now, I've just talked about that in a very simplistic way. We are going to go through that step by step right now. The trial. Picking a jury. Voir dire. So how do you get picked for jury duty? You're on a list. It's random, but once you have served as a juror, you have a 6-year hiatus. How do they get you? If you are you got your driver's license in New York, when you sign up for your driver's license, that's one way. If you are registered to vote, that's another way. You get on the list. You'll get a mailing in the mail that says, oh, you've been picked to be on a jury, report such and such a day. Gives you some instructions. So now we have our jury. We have a whole panel of people who show up for a jury trial. What the judge will do, will take sections of people, little at a time. Usually it's, over 100 people who show up for this, depending on how large of a jury is needed. We'll talk about that in a second. The book says 12 people at a time. The judge and panel's 20 to 25 at a time, because it's quite a lengthy process. 20 to 25 people at a time. The judge swears them in, because they have to ask honestly, because they're put under oath. They swear them in. And the judge asks them a series of questions. The judge will ask the same series of questions. Do you know the prosecutor? Do you know the defense attorney? Do you know the defendant? Do you know me, the judge? Do you know anything about this case? Kind of sets the stage. He'll say a little bit about the case. Then the prosecutor gets to stand up and ask questions of the potential jurors. And then the defense counsel gets to do it. And what's the point of all of this? To get an impartial jury. That's the point, to get an impartial jury. And the jury members, right before they come in to be questioned, are filling out questionnaires about their background, about their education, whether they're employed, whether they've ever been a victim of a crime, whether they've been through the criminal process or have ever sat on a jury before. Trying to get an idea or a picture of these individuals who are going to pass judgment on the defendant. And the goal is to get an impartial jury. So for some examples, if, let's say, the defendant is African American, and a jury, through questioning, says something racial in response to a question, they are impartial. If someone's related to a witness, they're not going to be impartial. So these are the things that these questions do to help flush them out. And once the questioning is done, the defense and the prosecution get to challenge them based on their answers. They're challenged for cause, i.e., if there's a clear signal that they're biased, like some will come right out and say, yeah, I can't be impartial. This is a sex offense and that it's appalling. And, I don't want to be here. I would totally rule in favor of the prosecution, right? That would put somebody on the cause list. If somebody was a victim of a theft crime and now they are looking at a defendant who's charged with a theft crime, they might say it'd be hard for them to be fair. Some people say, well, they must have done something. They're charged them. They got a charge on them. They must have done something. That is a signal that they are biased and they will be challenged for cause. And either party can make the challenge. And both sides get to do this. The prosecution gets first dibs at excusing people for cause, and then the defense. And then each side gets what's called peremptory challenges. That's a certain amount of strikes where you get to remove a prospective juror without any reason or any cause. And each side gets a certain amount depending on the seriousness of the crime. The more the serious the crime, the more strikes that counsel gets. Can you see a problem with these strikes that challenges? And they're not challenges, they're strikes. That's what we call them. Any problems? Can you see any gender issues or racial issues? Trying to stack the jury with all women? Maybe try and get a sympathetic ear if it's a child abuse case. Prosecutors kind of like to do that. There's also a very famous prosecutor down in Mississippi who would use their challenges to remove African Americans off the jury when there was a African American defendant. His name was Curtis Flowers. This happened 6 times. Why 6 times? Because each time the appellate court overturned it due to prosecutor misconduct based on bouncing jurors. They call it the Bastin challenge, and it's unconstitutional, where there's a pattern of strikes suggesting that counsel is using them for improper challenges such as racial and gender removals. And you should Google him. There's actually a big podcast on Curtis Flowers, 6 times. And so this prosecutor has had 6 different cases. Do you think it's hard to find an impartial juror? We got technology, we got news at our fingertips, our smartphones with info on it, right? Even though jurors are said, don't look at any information about the case. What happens when someone tells you not to do something, to look up something without a case, right? You're going to look it up. You hope that you don't. The judge gives a series of instructions every time a jury panel leaves the room. Like when he does there might be a bathroom break or a lunch break. Don't talk to anybody. Don't look at social media. Don't seek out information about the case. Don't talk to the attorneys or the defendant. There was a case out of Syracuse where a jury member spent a lot of the time texting out the jury what was happening in the courtroom, how she had her cell phone in the courtroom. I don't know. Normally they take those away, but I guess it's a court-to-court rule. But she was texting or had access to her phone, texting out her opinion on the case to family members, and ultimately it was overturned on appeal. What do you think happens if it's learned during a trial that a jury is using their phone, the internet, to look up case? I just told you it gets overturned, but it doesn't go away. It comes back. There has to be a new trial. So all of that has to happen all over again. All right, oops, I just jumped the gun and flipped my screen. Sorry about that. I got a couple more steps here. Counsel's opening statements happens after voir dire. People go first. They outline their theory of the case, what the evidence they intend to use to prove their case, and they must make one. They must make a statement. The people must make a statement. The defendant doesn't have to make an opening statement. They can reserve it for their turn of the case. But almost always a defense counsel will make one because it's their opportunity to get in front of a jury, even if they say the people can't prove their case beyond a reasonable doubt and outline that, the defendant's innocent until proven guilty, and you need to hold the people to their standard, and you got to listen to all the evidence. So the defense does not have to make one. Prosecutor's case. They have the burden. They go first. They have the burden of proof. Remember? Prove the case beyond a reasonable doubt. The defendant doesn't have to do anything. So let's talk about evidence. What's an example of evidence? There's this thing called direct evidence. That's the stuff that's the testimonial evidence. Well, one example is testimonial evidence. You got a victim, you got an eyewitness, you might have the investigator, law enforcement agent, a cop who made the arrest. You might have documents as a prosecutor, documentary evidence, lab reports, fingerprints. There's public documents that can come in, maybe text messaging. Maybe the text messaging was involved, communication between the defendant and the victim. There might be an audio video, 911 call. There might be a bystander who had their cell phone out ready videotaping. That can come in. Anything that's real or physical is direct evidence, a weapon, photographs, maps, any diagrams, any of those things that come out at trial from the prosecution is called direct evidence. And then there's something called circumstantial evidence, and that's indirect evidence. Okay, that's the evidence that ties it all together. It is what a jury can infer in order to prove a fact, right? Let's say fingerprints is direct evidence. We got the defendant's fingerprints on the windowsill of the house. Let's talk about a burglary case, and then ultimately somebody was killed in there, right? That's what we're going to work with my example. Okay, that's nice. You got the defendant's fingerprints on the windowsill. Does it prove that the defendant committed the crime? No, it just shows that the defendant had access to the house or was at the house at some time touching that window frame, right? So that's circumstantial. What the prosecutor wants is the jury to infer that, oh, okay, we got defendant at the house. There's some connection here, right? That's what circumstantial evidence is. How about a murder case? Evidence that carpet fibers found on the body match the carpet in the defendant's home. Does that prove defendant killed the victim? No, but it links the two, right? It links it. You're in a subway, you're just getting off the subway, you see people with umbrellas, their coats are dripping wet. What do? You infer that it's raining out. You don't see the rain because you're still in the subway, right? You look at the facts and you infer and then conclude. That's circumstantial evidence. Direct examination, that's the prosecutor is questioning, asking the questions and of the witness that's taking them through the storyline or the narrative. The cross-examination is when the defendant gets up and interjects or seeks information from the particular witness. Witnesses give facts. They don't give opinions, they give facts. Experts give opinions. Doctors, a lab technician, they give opinions. So what's an example of facts? The car was blue. Defendant was wearing a red coat. I saw the defendant run out of the front door, turn right, and head down Main Street. Those are facts. An opinion, a witness opinion, which would be improper, would be something like, well, the defendant must have done it. Why would he be running? That's not a fact. That's an opinion of a witness. All right, step 4. The people rest. The defendant will make some sort of motion that the court must dismiss this case because the people haven't proven some element of their crime. That has to happen in the process of things in order for a defendant to get an appeal. So the defendant has to make that request of the court. Rarely is it ever granted. The judge will either just say, I deny, I'll reserve that decision for later. Then the defendant has the opportunity to present a case. And if they did not make an opening statement at the beginning, this is where they would make their opening statement. The defendant does not have to. They can stand up and say the defense rests and just leave it all on the argument that the people haven't proven their case beyond a reasonable doubt. The decision of whether the defendant testifies, because this is where the defendant would testify if he or she was going to do so, that is left solely to the defendant. If the defendant says to their attorney, I want to testify, the attorney cannot say, no, you're not going to. Stay right where you are. That can't happen. They have an absolute constitutional right over the objection of their attorney to testify. And at this point, they can call any witnesses that they may have. So when the defendant is done, there's closing arguments, or summation, as it's also called. And this is where the attorneys assess the facts of the case and present them to the jury in a way that they want the jury to see it. In New York, the defense goes first, and the people have the final say. In other jurisdictions, it's the opposite, where the people will go first, and then the defense would go, but then the prosecution would be able to rebut anything that the defense says. So they would get 3 strikes. And here's a side note: if you ever watch crime shows, because they do it and they set it up this way in crime shows too, but this is the way it's set up in court, is the people always sit closest to the jury. The prosecutor will always be the attorney sitting closest to the jury, and that stems from the fact that they have the bigger burden. They have to prove, they have the case, they have to prove this beyond a reasonable doubt. So that's why that happens. All right, now here's where I should be flipping my slide. So then the court will instruct the jury on the law, including the elements of the charges. And then the jury will go off to deliberate and have discussions. Sometimes it's very quick. Sometimes it's extremely long and can last days. They can ask the judge for readbacks of some of the testimony. They can take any exhibits that have been entered into evidence and look at them, whether it be the weapon, if it's a murder trial, or if it's the drugs from a drug case, photographs. They're allowed to take all that back with them. If we're dealing with a high-profile case, such as O.J. Simpson's case, very sensational, a jury might be sequestered, which means they're locked up and hidden away, and they can't go out in public, and they can't go home. They meet privately. They can only talk about it amongst each other and never discuss the case or until the judge directs them to. And they deliberate until decided. And then the question is, what if they can't decide? The judge will continue to give them warnings and to tell them to try really hard to get there. But if ultimately they cannot decide a case, the court will declare a hung jury, and the prosecutor will have to decide whether or not to retry the case. If the jury comes back with a not guilty verdict, it's over. Case is done. Defendant gets to leave. Nothing else happens. If it's guilty, the defendant gets to appeal. Well, the defendant will then be sentenced, and then we'll get to appeal. We're going to talk more about sentencing in the next chapter. Jurors are instructed to follow the law as given by the judge, but sometimes and in rare instances they disregard the law and follow some preference or emotion. Prime example of this was its pre-Constitution, the Zagar case. It's always in legal books. It's Zengar was a editor of a newspaper who was charged with printing unfavorable material about the governor of New York. And there was a law that says you can't speak ill about public officials even if it's true. This was a form of censorship. This was pre-First Amendment. And despite the fact that he clearly printed unfavorable material, the jury found him not guilty. And this sent the message, and then hence we have our First Amendment and so forth. And there was this number of other cases that followed, either, all the way up to the Vietnam War. People were arrested for protesting the war, and jurors were nullifying or not following the law and coming back with not guilty verdicts. They call this jury nullification, this concept, and it is not widely known, despite the fact it is available. Jurors are never advised, ever, when they come to court by either the party, that they have this power to, completely disregard what the judge says, and you can have a not guilty verdict. No, because they are instructed to follow the instructions, and they're actually under oath to do so. So to use this power or be told about this power can get folks into trouble, including the parties. The court can never discuss it. The defense, the prosecution, nobody can refer to it in any way. But it's out there. It's always talked about in legal books, like I said. Step 9 is the sentence. If found guilty, the judge does this. It won't happen right after the guilty verdict. The judge has to order a report from the probation department, who will review the defendant's background and prepare it's called a pre-sentence investigation report. Prepare a report for the court, and they will come back at a later date, and the judge then would pass sentence. The appeal is final. As the next final step, the defendant is entitled to one appeal as of right. And then the next level is by application, requesting to be heard. In New York State, we go from the appellate division. This felony court case would happen in county court. And if the defendant was found guilty, it would go to an appellate court as of right. And then if the defendant wanted to appeal to our next highest court, the Court of Appeals, they have to ask for it by application. And on appeal, the defendant will raise numerous points of error and contention that occurred during the pretrial stage and at trial. These are things relative to the judge, what the judge did wrong, what the maybe misconduct of the prosecutor, those defense issues. My defendant was sleeping at the wheel, right? Basically any violation of a constitutional right. Ineffective assistance of counsel, violation of due process. The court read the wrong jury instruction. The evidence didn't support the conviction beyond a reasonable doubt. Counsel was ineffective. Did I say that one? There's a number of reasons that issues that the defendant can raise, and it only can be raised relative to what happened in the court proceedings. Remember, it's not a retrial. It's what happened in the court proceedings, and the appellate court isn't just going to review the information and say, oh yeah, the jury got it completely wrong. There has to be some error that could have made the jury conclude wrong. So that is the appeal writ of habeas corpus. I should mention what that is. After the defendant has exhausted all their legal remedies, that means taking their appeals all the way up as far as they can go, they have the right to ask a federal court to review the matter. They have to make an application, or this writ of habeas corpus is what they're asking for. They're petitioning for a writ of habeas corpus. Certainly, they can also ask the Supreme Court for a writ of certiorari, when we talked about the Supreme Court, to review the case. But the writ is for a challenge to their incarceration. The writ to the Supreme Court is a review of the case based on some constitutional issue. And that's how I'm going to leave that. We don't have to go into that in great detail. So that completes Chapter 8. Chapter 9 is all about sentencing, and we'll be covering that next week.